Court of Kenya has today ruled that spouses are not automatically entitled to a 50-50 distribution of matrimonial property upon dissolution of a marriage. In a judgment delivered Friday, the court cemented the famous 2007 Echaria versus Echaria case, which noted that the distribution of matrimonial property should be based on the contribution made by each party, through a matrix to be determined by the court. And as Laura Otieno reports, the court ruled that matrimonial property disputes filed before the 2010 Constitution was subject to the Supreme Law.
In the decision delivered Friday in a case stemming from a dispute between Joseph Ombongi and Martha Bosibori, who were married under the Abagusi customary law in 1990 and whose marriage broke in 2008. Martha moved to court to seek entitlement of benefit from the matrimonial property they acquired in Embakasi and put-up rental houses. While the High Court gave her 30% of the matrimonial property and 20% of the rental units, the Court of Appeal split the property 50-50 between the couple, prompting the appeal by Joseph Ombongi in the Supreme Court. The top court pronounced that while Article 45 of the Kenyan Constitution prescribed the equality of spouses in the dissolution of a marriage, the equality does not expressly mean the 50-50 split of property by fact of being married.
Why do you even want to walk out of that marriage? You should stay there. If you want to go venye ulikuja na hiyo bag moja ulikuja nayo. Yes, it is, I support it fully.
The court guiding that a party must issue proof of contribution to the said property to enable the court to determine how the property will be shared. The judgment further detailing that the burden of proof will lie with the party, with the court expected to give the determination of the split on a case-by-case basis. The judgment detailing that the intention was not to reward parties that don't make monetary or non-monetary contributions in marriages upon its dissolution.
Vitu zingine lazima mnaeka anda yeye ndo at least nyumba kai to the head, unaona. So vile itakuwa T50 hiyo itabidi tu tutakuwa tunaweka rishiti.
Kama alinipata saa zingine nimeshaunda pesa na nataka tugawane katikati, hiyo iwezekani. Sasa ile ambayo alinipata nayo ataniwachia. Ile tulitengeneza kama tuko na yeye, hiyo nitamgawia tu kidogo, si ati tunagawana katikati.
The Supreme Court further guiding that while Article 45 of the Equal Right of Partners in the Marriage shall be applied retrogressively, with guiding principles drawn from the Echaria versus Echaria case of 2007, which noted that the distribution of wealth upon the dissolution of a marriage should be based upon the contribution made by each party. According to the judges, Article 45 of the Constitution only provides a basis of equality at the time of the dissolution of the marriage to ensure that each party gets its fair share of the property. Laura Otieno, Citizen TV.
What are your thoughts on the distribution of matrimonial property?